Good morning, everyone. I call to order the joint meeting of the Courts of Justice and Public Safety Committees. Madam Clerk, if you could please call the roll.
Thank you, Madam Chair. Calling roll for members of the Courts of Justice Committee. Chair Herring.
Here.
Vice Chair Watts. Delegate Hope.
Here.
Delegate Simon.
Present.
Delegate Lindsay. Delegate Sullivan.
Here.
Delegate Levine.
Here.
Delegate Heretic.
Here.
Delegate Mullen.
Here.
Delegate Bourne.
Here.
Delegate Delaney.
Here.
Delegate Carol Foy.
Here.
Delegate Scott.
Here.
Delegate Kilgore.
Here.
Delegate Bell.
Here.
Delegate Ranson.
I'm here.
Delegate Leftwich.
I'm here.
Delegate Adams.
Here.
Delegate Campbell.
Here.
Delegate Miares.
Here.
Delegate Campbell. Delegate R. Campbell.
I said here a minute ago.
Thank you. And then calling roll for members of the Committee on Public Safety. Chair Hope has...
Cheryl,
Yes.
this is Joe Lindsay. I don't think I was unmuted, but I'm here.
Thank you so much, Delegate Lindsay. Chair Hope has acknowledged his presence. Delegate Bourne. Delegate Plum.
Here. I'm here.
And Delegate Bourne, did I just hear you say here?
Yes, ma'am.
Thank you, sir. Delegate Corey. Delegate Lopez.
Here.
Rasul.
I'm here.
Here.
Delegate Price.
Here.
Delegate Levine has indicated his presence, as has Delegate Carol Foy. Delegate Helmer.
I'm here.
Delegate Cole.
Here.
Delegate Simons.
Here.
Delegate Jenkins.
Here.
Delegate Wright.
Here.
Delegate Robinson.
Here.
Delegate Wilt.
Here.
Delegate Ferris. Delegate Rush.
Here.
Delegate Davis. Delegate Campbell has indicated his presence. Delegate Coinier.
Here.
Delegate Batten.
Here.
Madam Chair, a quorum is present.
Thank you so much. Again, before we begin, I'd like to explain the ground rules for the testimony today. And just like last time and the week before, this committee and the Courts of Justice, the Public Safety Committees have had a long history of being courteous, respectful, and civil to one another. And while we may have different views on a wide range of topics, we've always maintained a high level of decorum and respect in our civil discourse, and I expect that the same will continue. To those watching us via webcast, thank you and welcome for joining us today. We listen to you and we take your views seriously. Your input is welcome and is important to us. We head into our special session. Again, if I can just remind members that, and repeat what the clerk has advised, is that this is a public hearing. So to the extent that you can possible, please keep your cameras on. I think we're going to unfortunately have to be in the practice of doing this given the COVID crisis, that this may continue into the future. But also, if you have a question, use the raise your hand icon, but I'm also monitoring the chat and I'm doing my best, but just please alert me or say something if I still am not calling you, but we're still in time with the witness. All right, with that, we will get started. Our first witness, actually, I'm going to pause for a second and turn things over to my co-chair here.
Thank you, Leader Herring. On behalf of the Public Safety Committee, having the opportunity to listen and learn from Virginia and national stakeholders has been very beneficial to this process. Most of all, I've been very impressed by the quality of the input provided by the public, and I certainly want to thank our IT staff for making that a possibility. I want to personally thank the public for being part of this process and assure them that we are taking their comments for the last few weeks very seriously and onward. I'm looking forward to today's hearing, the final hearing, focusing on the use of force, no-knock warrants, and maybe most importantly, civilian review boards. In my opinion, civilian review boards must be the centerpiece of police reform. If done right, they have the potential to create much needed transparency and accountability in law enforcement. The only question in my mind is how do we best implement these boards and assure they are functional across the Commonwealth? I know my own jurisdiction of Arlington is deep in discussion of creating a civilian review board, and others already have one or are beginning those conversations right now. We need to give them the proper tools and support in order to be effective. I know at the conclusion of these hearings and with an eye towards special session, legislation will be introduced for our consideration that will likely fall into the jurisdiction of both of our committees. Leader Herring, I look forward to working with you, members on both sides of the aisle, to find solutions. Police reform and criminal justice reform ought not be a partisan issue. The public is asking for the General Assembly to take decisive action, and I believe that we owe it to our constituents to make these long overdue improvements to our police and criminal justice system. Thank you, Leader.
Thank you, Chairman Hope. All right, the first person on our list for our presentation today is Rayshawn Ray from the Brookings Institution.
Thank you, Chair. I want to thank you to Chair Herring, Chair Hope, as well as the other distinguished members of these committees. Thank you for being here. As we just heard, I'm Dr. Rayshawn Ray. I'm a David Rubenstein Fellow at the Brookings Institution. I'm also a professor of sociology at the University of Maryland in College Park. I also want to thank Cheryl Wilson, who has been amazing over the past couple of weeks, setting everything up and getting things together. So I thank you, as she'll be guiding through this PowerPoint. I'm going to present for about 10 minutes, and then hopefully you all will have some questions for the next 10 minutes or so until 10:30. Next slide, please, Ms. Wilson. So what we know, obviously, we are here because of what we've seen that happened in Minneapolis. But I've conducted research on policing for the past decade. I also come from a family of police officers, a family of people who have served in the military. And so I have a particular perspective that I come from that I think will be useful. Next slide. We are primarily here because of one primary statistic, but there are others. But the one that we need to highlight that's most important, that really captures the experiences of George Floyd as well as Breonna Taylor and others, is this graph that comes from police officers themselves, directly from FBI data. And that's the fact that Black people are 3.5 times more likely than whites to be killed by police when they're not attacking or have a weapon. And a Black person in the United States is killed every 40 hours. And that's something that should unnerve us all as we move forward. Next slide. One thing we know over the past 30 years or so is that justifiable homicides, and these are just the officer involved killings that lead to them being justified. There are another 500 or 600 every single year that are not ruled as justified, and I'll get to that in a second. But just among justifiable homicides by law enforcement, which is also known as death by legal intervention, according to the Department of Justice, is that we've seen a huge increase and a slight dip since we started seeing protests in Ferguson as well as up the road in Baltimore. But overall, these justifiable homicides are still at an all-time high over the past 30 years. Next slide. One thing we also know is that these justifiable homicides do not correspond to violent crime. This is looking at violent crime from 1990 through 2016. And even though we've seen a slight uptick over the past couple of years, which tends to happen as we see unrest, violent crime is still at an all-time low, even if we go back to the 1960s. But obviously the media would oftentimes have us to think that we're living in a much more violent world than we actually are. and the research simply doesn't bear that out. Next slide. Next slide, please, Ms. Wilson. One thing that we do know, though, is that we do have a series of civilian payouts for police misconduct. Ms. Wilson, you might have to press a couple of times to get some of these other images to pop up. Okay, that's good. Go back one. One thing we know is from high profile incidents around the country, from Walter Scott down the road to Freddie Gray right up the road in Baltimore, to a series of others. Corinne Gaines in Baltimore. If people haven't heard of that particular incident, they should, because as we're talking about no-knock warrants is relevant. The research I've conducted highlights that civilian payouts for police misconduct, where overwhelmingly these particular incidents are ruled as justifiable, but they are ruled in a civil court to not be justifiable, leads to local jurisdictions paying out millions of dollars. If we just take Chicago as a city that is oftentimes highlighted nationally, the city of Chicago has spent over $650 million over the past 2 decades on civilian payouts for police misconduct. Imagine if that money was put toward education equity, if it was put toward work infrastructure. And of course, as you all know, what the public oftentimes doesn't know is that these monies oftentimes come from general funds. They actually don't come out of the police department's budget. So in a lot of places, the police department makes up over 1/3 of general funds. And then on top of that, taxpayers are paying out civil settlements. So eventually George Floyd's family, Breonna Taylor's family will receive large civil payouts for their killings. And their tax money is going to be used to pay them back for the dehumanization and wrongful deaths of their loved ones. And I think these are things that, regardless of where we stand along the aisle, these are things that we should work to correct. And I'll get to what we need to do about that in a second. Next slide, please. You can actually scroll past this next slide as well, because it's similar to this one. This is just highlighting other incidents, including 12-year-old Tamir Rice, who was killed playing with a toy gun in a park. These monies came out of the general funds of these particular places. Next slide, please. This was a study on stop and frisk. A big question that you all have on this committee is how we think about no-knock warrants, how we think about use of force. And I think we can't talk really about use of force or no-knock warrants unless we're transparent about racial bias. And this is something that I've done research on for quite a long time. This was a study done in New York City around stop and frisk data. What you see here is that in the year 2011, there were over 700,000 police stops of people walking down the street. What the bottom line you need to know is only 2% of those stops led to the discovery of contraband. However, 50% of these stops were of Black people, 1/3 were Latinos, and less than 10% were white. And when use of force was used, if you look on the right underneath that police car, you see that force was used an extraordinary amount of time relative to what was actually going on. So what's happening when it comes to research is that oftentimes police officers are using their script when it comes to criminal behavior to actually look at whites. But when it comes to looking at Blacks or Latinos, they are oftentimes using their skin tone as a metric by which to make these decisions. Next slide, please. Obviously, when we talk about no-knock warrants, we could talk about Breonna Taylor and what happened in Louisville, Kentucky. Next slide. This is a graphic showing, this is actually from New York Times. This is a graphic showing across the country where different states fall. So Virginia obviously is doing much better than others in terms of saying that it's not routinely granted, but forcible entry is allowed under certain circumstances. That's something that should be looked at. Kentucky has something similar, which is the reason why people have been upset about what happened with Breonna Taylor, which is different from other states that we might see across the country, like the Carolinas, Georgia, Tennessee, and even Maryland. Next slide. When it comes to no-knock warrants, when SWAT is deployed, overwhelmingly they are being deployed as it relates to drugs. Next slide. And when it comes to these deployments, about 80% did get a search warrant before they went in. But part of getting the search warrant is to actually get a warrant so that, of course, they can use no-knock warrants. Next slide. This is where it becomes problematic. What we actually see, though, is that when SWAT is deployed, we see huge racial disparities across the country. So similar to the gap in officer-involved killings, the racial gap in officer-involved killings, we see a similar gap when it comes to the way that SWAT is deployed. Next slide. We also know that where SWAT is deployed to conduct these searches, particularly drug searches, that the neighborhood composition varies quite a bit. On the left side, these are predominantly white neighborhoods. On the right side, these are predominantly Black or Latino neighborhoods. We see that in racially integrated neighborhoods, which aren't that many across the country, oftentimes they're either predominantly white or predominantly minority neighborhoods, that we see huge disparities if we look at that red bar in when SWAT is deployed for drug searches. And what's important to note is that research also documents that there aren't any racial differences in people's usage of drugs, but we see a huge gap in the way that SWAT is deployed in these different types of neighborhoods. And this really highlights Breonna Taylor, because we know that that when they went into her home, they actually had the wrong home. That happens quite a bit because they are oftentimes targeting neighborhoods. And there are people who are living next door to other people who are not responsible for what their neighbors do. And they shouldn't necessarily take on the baggage, or what my colleagues, Dr. Ali Sewell, as well as Dr. Keon Gilbert, have highlighted, the illness spillovers of police violence. One thing that we know from our research, we just published a new article in a top international journal, that people who live in neighborhoods that experience a hyper level of policing, that their health suffers. Men's mental health suffers, higher level of depression, higher level of anxiety. But for women, their physical health suffers. Their obesity rates are higher, their diabetes rates are higher, and their blood pressures are higher. And this is controlling for every other factor. And this doesn't necessarily only include minority neighborhoods. These are any neighborhoods that are more likely to experience higher levels of police violence. And this is also controlling for crime, that we still see these patterns playing out. Next slide. Go ahead. Sorry, I couldn't hear you.
Sorry, you've done 10 minutes, so I just wanted to look at your time.
Okay, I'll wrap up in 2 minutes.
Right.
One of the big things we need to also notice is the racial gap in the way that search warrants are deployed. And we see this here on the right side. Next slide, please. Part of this highlights that not only do we see people being targeted who haven't committed a crime, but we also know that the violent crime clearance rate is unacceptable, that police officers aren't as successful as we would like them to be in solving violent crime. About 40% of murders go unsolved every year, 66% of rapes, 70% of robberies, and 50% of aggravated assaults. Next slide. We also know that the response rates are lower, and people in Black and Latino neighborhoods wait much longer for a police officer to arrive when they call 911 and when there's been an incident. Next slide. Final two things I'll say is, let me quickly talk about civilian review boards, which I think are important. But in order for them to be highly effective, there needs to be civilians on the internal trial board within police departments. If not, civilian trial boards are simply symbolic. They don't actually have an impact on holding police officers and police departments accountable for their treatment of others. This will create transparency. It will also build trust with the community. Next slide. And the final thing I'll say is, we've conducted a lot of research with police officers. We've done, go back one. We've done research with thousands of police officers, conducted implicit bias trainings. We've done interviews with hundreds of them at the Lab for Applied Social Science Research, and we overwhelmingly find that officers have implicit bias against Black people, and that this leads to a lot of the outcomes that we see. All right, you can fast forward 3 slides and I'm done. All right, thank you for your time. And if you all have any questions, next one more slide. And if you all have any questions, I look forward to those. You can scroll through, I think it's 6 of these that will highlight how I think about police reform.
Thank you so much. And I do have some questions, but before I get there, I want to take this time to again welcome our speaker, Eileen Philipporn. She's been with us throughout all these proceedings and I just thank her for her leadership to make this pioneering effort happen for us in the House. So with that, I am going to now turn it to Josh Cole for your question. Delegate Cole.
My apologies. I think that was from the test earlier today.
All right, I'll move on. Delegate Kilgore.
Same.
All
Same. Right. I need to figure that.
That's all right.
There's another button to lower your hand too. That you
I see that now.
There you go. Delegate Lopez. Oh,
I've just lowered my hand.
All right. Well, Mr. Ray, you probably explained everything so well. All right, I'm moving on along. Delegate Campbell. All right. Delegate.
I'm sorry, I couldn't get the thing unmuted.
Oh, okay, there you are. Delegate Campbell.
I basically have two questions, I guess I would say. The first one is when you were talking about stop and frisk, 50% Black, 30% Latino. It's my understanding that New York City is approximately 70% minority. So it looks to me like these numbers are pretty consistent with the makeup of New York. And the other thing was I noticed that your slides, all of your information seems to be about 8 years old. And if you're looking at 2018 FBI statistics, things are a little different than some of your slides. Was you aware of this?
Yeah, so on the last front, I have a lot of slides that are up to date to 2018, and I'll be free to have Ms. Wilson share that with you, as well as some of the writings that I've also done. Things haven't changed that drastically. The dip we've seen in justifiable homicides, that was the slide I put up, that was through 2018. In 2020, things are actually on the rise. Even since George Floyd, we've seen use of force go up. As it relates to New York City, and this is an example of anywhere around the country, we can't really look at racial composition to compare crime, because if you remember what I said about that, I said only 2% of those people who were stopped were actually committing a crime. So simply because you have the racial composition of an area that might have a higher minority population or a higher white population, that doesn't justify the number of stops, nor does it justify the use of force. And so when we look at the stops are proportional. What we would then like to see is officers being more successful in their ability to stop people who are actually committing crime. And part of what I'm highlighting is that they're not that successful at all. And I think we could all agree that part of the reason why stop and frisk has been ruled unjustifiable is because it has been so unsuccessful in terms of actually being able to prevent crime, despite what people say in the media. The research doesn't back that up at all. Something being 2% successful, and I work with policymakers a lot, I don't think any of you all would support a policy that's only 2% successful. And so, we have to look beyond racial composition. And part of what that graphic highlighted, and of course I was speeding through it because of the time, is highlighting that we can't use racial composition as a justification. Simply because an area is predominantly white, that doesn't necessarily justify not only more stops being white, but more so we have to look at whether or not the stops actually correlate to the stops being equivalent to people who are actually committing crime. And that success rate is just something that the public shouldn't accept. I think there's another question in the chat, maybe. I don't know if that was Delegate
Madam
Martin.
Chair, you are muted.
Sorry, thank you. Delegate Rasul.
Thank you, Madam Chair. Question. I know with the limited amount of time, you probably were not able to get to the solution that you had referred to earlier with the payouts that have been coming out of general funds. I imagine maybe you can briefly mention what you think some of those solutions are and maybe how they tied to qualified immunity here in Virginia.
Yeah, thank you for that question. I think the big solution to deal with the civil payout so that the money isn't coming from general funds, and we're spending millions of dollars there. And also in a lot of jurisdictions where they don't have a lot of income, it is literally making them go bankrupt. I think the solution is to have police department insurance policies. A lot of small municipalities do this. They also band together. We do this in healthcare every single day, where we have hospitals that have insurance so that when physicians, healthcare providers, nurse practitioners, nurses do something in the hospital, and oftentimes these are just mistakes. And for law enforcement, that's the same way. These are mistakes. But when a person loses their life, there is financial culpability. So I think a way to circumvent qualified immunity is to have police department insurance policies. We already have a model for this in smaller jurisdictions. I think this will also give police chiefs, who I talk to quite often, and in fact, would talk to one growing up because my great uncle was the first Black chief of police in my hometown. And they would talk about their inability to get bad apples out of their department. This all of a sudden takes a market-driven approach to this problem. And what it will do is say, look, Derek Chauvin in Minneapolis, you've cost us X millions of dollars over the past decade. We can no longer afford to keep you here. This market-driven approach tells us that, and it's not coming out of general funds so that you all might be able to provide other social services across your area.
Thank you. One last question, Delegate Sullivan.
Thank you, Madam Chair. Dr. Ray, I was interested in your comments about civilian review boards. Could you give us another 90 seconds? You had talked about having civilians on the internal boards rather than, I guess my question is, do you see that as rather than a separate civilian review board or in addition to?
It's a great question. Thank you for that. I see it in addition to, and I'll tell you why. So I've been a part of a lot of these civilian review boards across the country, including in the DMV area in our region. I've also served on committees for hiring police chiefs. And one thing I noticed after doing all my research and serving in this way is that the civilian review board is simply symbolic, because oftentimes what happens, the internal review board within a police department, there are typically three people, particularly in large departments, there are three people, typically a major, a captain, and someone else. They serve as judge and jury over misconduct. And the research I've done shows that Black and Latino officers are sanctioned harder. They are also given more discipline relative to white officers. And the civilian review board only gets to look at or make a ruling on what happened inside the department after the fact. So their ruling doesn't mean much. And this is the reason why a lot of police chiefs are like, yeah, sure, we'll have a civilian review board, because they know that it doesn't really have a big impact internally. If we want to create more trust and transparency with the public, and if we want to ensure that officers, regardless of what they look like, that they are treated equitably within the police department, because if they're not treated equitably internally, they're not going to treat people equitably externally, which is what we want. We have to have civilian representation on the internal trial board, in addition to the civilian review board from the community.
Thank you so much. Thank you so much, Mr. Ray, for being with us. Dr. Ray, I'm sorry. Dr. Ray, thank you so much for being with us. I appreciate you.
Thank you all for your time. Thank you.
Next, we have Harold Foley from the Legal Aid Justice Center.
Good morning, all.
Good morning.
Okay. I was seeing if I was still on mute. So I want to put a disclaimer out there first. I am not an expert in creating sausage and understanding the legislating process, but I am a messenger from the community. And I have, if you have any questions in regards, I have a slew of lawyers who can help me with that, and I can point you into the right direction. Good morning, Madam Leader and Mr. Chair. Thank you for the opportunity to speak with you today. My name is Harold Foley. I'm an organizer with the Legal Aid Justice Center, Civil Rights and Racial Justice Program. This morning, I'm here to discuss why Virginia needs civilian oversight bodies with subpoena power and final disciplinary authority. For nearly 20 years, I've dedicated myself to organize, mobilize communities across Virginia. policing among the top concerns of the communities that I serve. While working on police accountability efforts with LAJC and the People's Coalition in Charlottesville, I have heard countless stories of police misconduct. One example, Miss Eubanks, in the fall of 2019, she was concerned about an assault on her daughter. In the early mornings, hours of August the 24th, her daughter was approaching a CPT officer seeking medical help for a victim who'd been stabbed 6 times. Instead of helping, the officer placed his hands around her neck and choked her out of the way. Her daughter never thought it would happen in her town, Charlottesville, but her views on policing in her hometown are changed forever. So her daughter, I talked to her about her daughter going to do a complaint at the Charlottesville Police Department. She convinced her daughter to go. Her daughter gets there and she goes to file, and she gets at the door and she get unfriendly. Her experience was unfriendly to the officer was unfriendly to her. When she went to do her statement, they kind of targeted her and they kind of interrogated her. They asked about her tattoos. They asked about her brother who was not there. She finally got a result from the complaint, and the use of force was not resolved. So again, the daughter was concerned about not going because nothing would happen. And of course, nothing did happen in her eyes. As a former incarcerated Black man, I also have a personal stake in this issue. My communities have not been policed in the same way as affluent white neighborhoods. The connection between the experience of a community member and my own is that neither of us had a seat at the table to determine how we wanted our neighborhoods to be policed. We're not involved in creating policies, police policies, procedures, making budgetary recommendations, or any of the policies that negatively impact us. In August 2017, white supremacists descended on Charlottesville in what we call the Summer of Hate. It was especially telling to see how the Charlottesville PD refused to protect and serve our citizens. Their response to armed white supremacists did not match the daily interaction with Black and brown people. As the people who are directly impacted by district policing, we best understand how policies determine our lives and how to correct that harm. Shortly after the Summer of Hate, we began organizing civil oversight. In December 2017, the Charlottesville City Council passed a resolution to create an initial civilian review board. Their charge was to create the bylaws that will be further used in a civilian review board. It was many folks out there working on the same issues. We came together and we created the People's Coalition. People's Coalition has nonprofits, individuals, and all what they did was they created a space to organize around the Civilian Review Board, research, and have folks give their testimony. After years of struggle, Charlottesville established its third civilian oversight mechanism. Unfortunately, our Civilian Review Board is weakened and limited by lack of resource, statutory power to hold police department accountable. Our city council lack both the moral strength and legal authority to enact the type of civilian oversight our community demand. We need you to give us the tools to finish the job we began in 2017. We need the state to allow meaningful oversight of law enforcement. I'm calling on you to support the legislation that will empower localities to create a civilian oversight of law enforcement. Let localities decide in their bodies, let localities decide if those bodies should have subpoena power. Let localities decide which complaints those bodies should have final disciplinary authority over. One of the amazing thing about having a civilian review board is transparency. And transparency includes subpoena power. So we want to grant the community the authority to access police department documents, data, records that have been hidden from view. Authorized to call witnesses who are not willing to participate in hearings. Grant the power to review budget, make budgetary recommendations, policy change. Finally, what I really wanted to push is we can't trust the police to police themselves. People directly impacted by policing should have the power to determine how misconduct is handled. In closing, I want to thank you so much for allowing me to give a statement today about the importance of a oversight board. One thing I know for sure is, like I said before, I'm not an expert in how bills are created or whatever it takes to make this happen. But I am a messenger from the community, and the community is asking you all to please give them the power they need to have a strong civilian review board with authority to subpoena and authority to make recommendations on misconduct of officers. Thank you. And I am, at this moment, if you have any questions, please, I'm open.
Thank you so much, Mr. Foley. Does any member have a question? I see none, so I appreciate your coming here virtually and to testify. I appreciate you. Thank you so much.
Thank you.
Now we have Mr. Wayne Huggins from the Virginia State Police. Welcome.
Thank you, Madam Chair. Madam Chair, Mr. Chair, thank you so very much for affording me this opportunity. I'm not here today to speak for the Virginia State Police. However, I am here to speak about the Virginia State Police and on behalf of the 2,400 members of the Virginia State Police Association. Let me begin by saying and making it clear, we are as repulsed by bad police officers acting badly and unprofessionally as anyone. It tarnishes our reputations, and all good police officers are tainted as a result. Simply stated, we do not want bad cops on our department. Furthermore, we do not want them to be able to jump from department to department, as we have seen happening. Additionally, we support the constitutional rights of our citizens to gather peacefully, to express their concerns about any issue, including police misconduct. My association with Virginia State Police goes back almost 50 years, with my last active duty assignment being as superintendent of the Virginia State Police. Having served as the CEO of public safety agencies on all three levels of government, as well as having served as the chairman of the board of the Commission on Accreditation for Corrections and as the executive director of the National Commission on Accreditation for Law Enforcement, I firmly believe that the Virginia State Police is one of the finest law enforcement agencies in the United States. I recall from my days as a young trooper, the two things I dreaded most at the beginning of my shift each day was the thought of either delivering a death message or the possibility of using force. While these are rare occurrences, they leave a lasting impression. Our troopers have thousands of contacts each and every day with our citizens. These contacts range from something as seemingly harmless as assisting a disabled motorist, issuing traffic summonses, investigating auto crashes, to criminal investigations and arrests. I firmly believe that 99.99% of these contacts are routine and incident-free. And I believe the Virginia State Police can provide you with statistical data supporting my opinion. On those rare occasions when force is used, each state police officer has an affirmative responsibility to report such use to his or her supervisor. That supervisor then has a responsibility to investigate the incident, and if the investigating supervisor believes a criminal act has occurred, our Bureau of Criminal Investigation is called on to complete the investigation. The results are then turned over to the Commonwealth's attorney having jurisdiction. If criminal conduct was not involved, but our personnel acted inappropriately, there are a variety of disciplinary tools available for use, and they are indeed used. Again, we do not want, bad cops wearing our uniform. Following an extensive background investigation process, once hired, our troopers receive hundreds of hours of basic training on topics such as use of force, Virginia State Police policies that govern such use, de-escalation tactics, crisis intervention, defensive tactics, and many, many others. These topics are then retrained upon during our biannual in-service training. Our basic training alone, to include field training, approaches 1,400 hours. Having said this, we are not perfect. We hire human beings, and none of us are perfect. Nonetheless, we are striving each and every day for perfection. We support common sense, meaningful reforms that can help us reach our goals. We support a decertification process that rids us of bad actors and prevents them from jumping to another agency. We support the banning of so-called chokeholds, providing the trooper is not involved in a life or death situation with no other recourse. We support the duty to intervene. We support the use of body cameras that come with common sense policies and procedures. We support enhanced training opportunities as long as the necessary resources are provided. And we certainly support national accreditation. The Virginia State Police was one of the first two state police agencies in the country to be nationally accredited, and we support other agencies following our lead. There are also topics being discussed that we oppose. We oppose the defelonizing of assault on a police officer. We oppose diluting or eliminating qualified immunity. This would affect all public employees, not just police officers. This topic is widely misunderstood, and the impression that has been advanced is that creating the impression gives us blanket immunity. That is not true. As the title suggests, a person must qualify for such immunity by acting reasonably in accordance with the Constitution, applicable laws, and department policy. This would open the door for countless frivolous lawsuits and would definitely become yet another impediment to hiring qualified men and women. And finally, we oppose any requirement that would cause hesitation in our decision-making process, such as warn first. Trooper Jerry Hines stopped a car on Interstate 81 at Lexington late one night for speeding. As he approached the car, he was shot at point-blank range twice, left dead on the shoulder of 81. What he did not know was the occupant had committed an as yet undetected double murder, was driving a stolen car, and had a hostage. Trooper J.A. Walker stopped for what he thought was a disabled vehicle. Before he could exit his car, he was shot numerous times and died sitting in his police vehicle. Trooper Gary Horner was dispatched to a rest area on Interstate 64 to investigate the report of a body in a sleeping bag on a picnic table. As he approached the suspect pulled a gun and shot Trooper Horner multiple times. Miraculously, he survived. These are but three examples of how quickly and without warning things can go bad for our troopers. And I could cite many, many more. In fact, last week, you heard from three of our widows who shared their stories. 2020 has been one of the most difficult years in the history of the VSP. It began with new responsibilities at the General Assembly, immediately followed by the pandemic. And by the way, we've had a number of troopers test positive, and now demonstrations we see occurring daily across our country. These conditions have and are taking a toll on the state police. We now have almost 300 vacancies, with another approximately 300 eligible to retire within next year. This high number of vacancies, new responsibility, and thousands of hours of overtime and time away from our homes and families, as I said, are taking a toll. Undoubtedly, there are other issues that will be considered, and it's our hope that we will be afforded the opportunity to participate in those considerations. And again, thank you so very much for the opportunity to appear before you today.
Thank you so much. I will now ask, I think Delegate Mark Levine has a question for you.
Yes, thank you, Madam Chair. And good to see you, Mr. Huggins. Turn your video back on. You mentioned the disciplinary proceedings that occur internally when a police officer is accused of misconduct. And as you mentioned, they don't always rise to criminal misconduct, but there's certainly misconduct that occurs, and you have your internal discipline. As you heard from Dr. Ray and Mr. Foley, there's been a suggestion that civilians be allowed into that internal review process so they can examine how that's going, and so that the public can hold the police accountable for misconduct. I want to know your views on that, and also, in addition to the Virginia State Police, if you feel qualified to talk about internal discipline in either police or sheriff's offices in Virginia.
Let me reiterate something I said, Delegate Bean, in the beginning. I cannot speak for the Department of State Police, so my comment is strictly a personal opinion. I personally do not have an objection with citizen involvement, provided there is some type of a training program that would be provided to those citizens. It would be tantamount to me sitting on a medical review board for a physician who's accused of medical malpractice. I know nothing about their profession or what they do. And it would seem to me that, again, strictly speaking for myself, that any person who is involved in these processes has to have, at the very least, a basic understanding of our profession, the challenges we face, the decision-making that we're called upon to make in a split second. And if that were to happen, then I personally don't see it as a problem.
Thank you.
Right. I have next is Delegate Bourne.
Thank you, Madam Chair. Thank you, Mr. Huggins. I've got just I think 3 questions, and so I'll ask them and allow you to answer them. Just to follow up on Delegate Levine's question about internal policies and practices when they don't and do rise to criminal level or not. Can you tell me how many VSP officers over the last, say, 5 years who have had these types of incidents have actually been decertified? That's question number 1. Number 2, you expressed your opposition to changing our immunity defenses related to excessive force cases for law enforcement officers. Can you tell me how many lawsuits or cases that have been brought have survived an immunity defense? And then the last question is, you talked about how you guys have training and you're, that you believe the state police are the best law enforcement agency in the country, and we certainly do have a good one. But how can you sort of rely on the training and that line of thought when we continue to see examples of misconduct like we saw recently that I think we heard from the Colonel in our first hearing about that had recently been disclosed by video? And how else would we hold bad actors, law enforcement agencies, and the localities or agencies that they work for accountable if we don't change our immunity laws and allow for a case to be heard and dispensed with on its merits rather than a legal defense that has been created by statute?
Delegate Bourne, thank you. In response to your question about statistics, I am no longer within the Department of State Police, so the numbers you're asking for, I believe, if I'm not mistaken, in your first committee hearing, Colonel Settle indicated that there had been 13, I believe that was the number, state troopers who had been decertified over a period of time. I don't have access to that information, sir, simply because I'm not within the department anymore. So any statistics that would come from the Department of State Police, I feel certain that Colonel Settle and the department would be able to provide those answers for you. I simply don't have access to that information. Regarding your last question about the immunity issue, that has to be granted by a court. It's not something that automatically happens. And again, as I understand it, and I am not an attorney, Delegate Bourne, so I would certainly yield to the legal minds on this matter. But my lay understanding is that a person has to qualify for, it's not not automatic. And you have to qualify, and you have to be able to demonstrate that you are acting reasonably in accordance with the Constitution, the laws of the Commonwealth, and the policies and procedures. If you are operating outside of those parameters, then you are not given that qualified immunity. Now, that's, again, my lay understanding of qualified immunity. And again, my lay understanding is that qualified immunity applies to all public employees, both state and local, not just police officers. So forgive me if I'm not giving you a complete understanding, but it's probably because I'm not an attorney. What I'm explaining to you is how I understand it.
Thank you so much. Next will be Delegate Price and then Delegate Bell. That will be it for the questions for Mr. Huggins.
Thank you.
Yes, Madam Chair, thank you. And Mr. Huggins, good to see you again. I enjoyed our conversation and getting to know more about your history within the department. So I thank you for sharing that again here. I was on a Zoom call yesterday and have also received a lot of emails and calls specific to defelonizing assault on a law enforcement officer, specific to the developmental disability community. And so yesterday I was speaking with advocates with the ARC who are coming from a place of fear for their loved ones who might unintentionally make a move. And they were sure to point out that developmental disabilities are not curable in the same way some other issues are. And so there has been a loud cry, from this community for that, so that they could help their loved ones stay from being justice involved for things that they cannot help from doing. What would be if you're against defelonizing that, what would be your suggestion then for this community and their absolute fears that they might do something wrong, though unintentional, and then end up with a felony charge?
Delegate Price, I think that once the parties involved have an opportunity to, and let's just say a charge is made for a person who is developmentally disadvantaged, does something strictly as a result of their disability, no malice, nothing like that. But I think, but is charged, the court certainly has the ability to take those circumstances into consideration and either now cross the charge, dismiss the charge, reduce the charge. To me, that's where the matter should be resolved, is in a court of law, where that authority exists today. And I find it hard to believe that a court learning upon that a person is developmentally disabled, mentally disabled, some other disability, incurable, couldn't help themselves. I can't imagine that the courts wouldn't go along with an action of either dismissing, now processing, or reducing. That authority exists today.
Yes, well, Madam Chair, I'm sorry to report that it is happening more often than not. And these families are not just afraid of what is going to happen with the felony charge, but also, as my colleague has pointed out, what might happen in the actual interaction on the scene. And so can you, and I think it might be Colonel Suttle that I need to get back in touch with, but can you remind me what the training requirement is for a trooper as it pertains to learning the nuances of even just the spectrum of autism in order for them to be able to best respond to something that might happen on the scene?
They receive extensive training, and that curriculum, it's been 20 years since I left the superintendent's office, and the training curriculum, I can tell you, Delegate Price, changes year in and year out. And as more is learned, that is imparted to our people in training, and they receive extensive training on like the autism spectrum. And I can tell you, it's probably been 45 years ago. I was at a movie theater in Falls Church, Virginia with my wife, and a young man walked into the movie theater and was creating a disruption. I thought that the person was drunk. I mean, it was falling all over people, creating a real disruption. I was off duty, but felt a duty to intervene. Come to find out, his mother walked in behind him, and this young man was suffering severely from autism. And once we understood what was going on, I didn't charge the person. In fact, I helped the mother take care of this young man. So I fully empathize. I've had that personal experience before. But again, just to reassure you, the department is very aggressive on training upon these matters. And I think, as you pointed out, the Colonel Settle and our training division would be the appropriate source to give you the exact particulars of the training they provide.
Thank you, Delegate Price. And Mr. Higgins, actually, because we were talking on training, I do have a question for you, if you know. Did the state police use a Dink Keller video in their training?
I do not know.
Okay.
I do not know if that's currently being used. And again, my experience is dated, so it may well be, but I just don't know.
I appreciate that. Thank you so much for being with us. Appreciate it.
Thank you, ma'am. It's been my pleasure.
Next is Lindsay Lawson. Sorry. Lindsay Lawson Battaglia, and I apologize if I butchered your name there.
It's Linda Williams, isn't it? Next.
Madam Chair, I believe the next speaker on the agenda is Linda Williams from Noble.
Linda Williams.
Yes, ma'am. Thank you.
Thank you so much. You can proceed.
Thank you. House Courts of Justice Chair, Ms. Herring, House Public Safety Chair, Mr. Hope, and members of the House of Delegates. I bring you greetings on behalf of the Executive Board, members, and constituents of the National Organization of Black Law Enforcement Executives, NOBLE. I am Linda Williams, and I serve as the National President of NOBLE. I'm currently a Professor of Criminal Justice Administration at Middle Tennessee State University and a Deputy Assistant Director, retired from the United States Secret Service. I began my law enforcement career with the United States Secret Service back in 1988. It is an honor for NOBLE to provide testimony on the topic of criminal justice reform. NOBLE joins the nation in condemning the policing tactics, actions, and inactions that led to the death of Mr. George Floyd. We are alarmed and mourn with the nation at the horrific killings of Breonna Taylor, Ahmaud Arbery, and most recently, Rayshard Brooks. These names represent just a few in a much longer list of tragedies impacting communities of color. We offer our heartfelt condolences and prayers to these families and to our grieving nation. The senseless death of George Floyd has gained unprecedented attention around the globe from people from every walk of life are collectively demanding that justice must be fair, justice must be transparent, and justice must be equal. Though it's very important that the Minneapolis officers involved are prosecuted to the fullest extent of the law, it is just as important that we address the systemic shortcomings and oftentimes failures of our law enforcement and criminal justice systems. Many police leaders have already accepted responsibility to work towards meaningful change and to effectively build sustainable relationships with community stakeholders. It is our opinion that a comprehensive approach is required in addressing the issues of police culture, accountability, and building trust between police agencies and the communities that we have taken an oath to protect and serve. Secondly, NOBLE is fully aware that addressing issues within the law enforcement spectrum is a very small part of a larger, more complex construct comprised of America's continued imbalanced distribution of critical resources. History has shown that minority citizens have been disenfranchised from the American dream from generation to generation. America would never realize her true potential until all of its citizens' humanity is equally valued and protected through racial and social justice. I'd like to share with you legacy and law enforcement precedent that we feel that must be addressed. NOBLE supports modernizing policing in our country through the following proposed national policies. First, prohibition on chokeholds and vascular neck restraints unless deadly force is authorized. Second, national review on the prohibition of no-knock warrants for drug cases. Third, implementation of a national registry of individuals who have been disciplined for use of force and dismissed from any law enforcement agency. 4th, national accreditation standards for law enforcement agencies. 5th, mandatory de-escalation and implicit bias training for law enforcement officers. 6th, limitations on qualified immunity for law enforcement officers. 7th, federal enforcement of the civil prohibition on a pattern or practice of policing that violates the Constitution and other federal laws. 8th, limited transfer of military surplus equipment. 9th, requirements for body-worn cameras for all law enforcement officers. National data collecting and reporting on the use of force by law enforcement is the 10th. In particular, I would like to address the following 3 areas in more detail. No-knock warrants, changing the standard for the use of force from reasonable to necessary, and reviewing qualified immunity. Noble calls for a national review or prohibition on no-knock warrants for drug cases in particular. We feel that law enforcement should have a necessary amount of time to knock and announce themselves. However, each case is contingent upon the circumstances and that officer's safety. Noble believes the use of force standard should be evaluated and strongly consider changes from the standard of reasonable to necessary. It is our understanding that the standard of reasonable is what is taught in Virginia. In our opinion, that there could be too much discretion provided to law enforcement officers under a reasonable standard versus a necessary standard. A key question to ask ourselves is, does the use of force applied, especially in the case of deadly force, align with the expectation of average citizens and the community? Noble recommends limitations on qualified immunity for law enforcement officers. We feel that qualified immunity should be reevaluated. Presently, under federal law, police officers who infringe on civilians' constitutional rights can be sued in federal court, but the qualified immunity doctrine shields them from such suits unless their action violated clearly established law. In our opinion, this standard sets a high bar that favors law enforcement. Our recommendation is to consider ways to create safeguards that address the present imbalance. Lastly, on behalf of more than 3,800 law enforcement leaders, mostly minority, who represent the membership of Noble, I thank you for supporting the law enforcement profession, but most importantly, for listening to the voices of protesters around the globe who demand change. They too deserve action. We also recognize that the majority of police officers who demonstrate on a daily basis their love and commitment to the tenets of the 21st century policing and safety and the well-being of the communities they so courageously serve. However, today at this critical time in history, Noble members and other colleagues who lead agencies across the nation appeal to your state to pass legislation that provides state guidelines to reform the system of policing for your citizens. It is critical that we first acknowledge the pressing need for a comprehensive and holistic approach to change and urgently begin the process of reimagining today's police culture and enlisting servants who value the sanctity of life. On this occasion, I am cautiously optimistic that in Virginia, the cries of our America will be heard and acted upon, so that once and for all, Black lives are valued in the eyes of the police as far more than a counterfeit $20 bill, more than a carton of cigarettes, and more important than simply showing up at the wrong address. I thank you, the House of Delegates and Committees, for allowing me to give my testimony. Thank you.
Thank you so much, Ms. Williams. I have the first question for you is from Delegate Watts. Delegate Watts.
Thank you, Madam Chairman. Thank you, Ms. Williams. My question has to do with independent auditors. In my jurisdiction, after several years of wide discussion, we ended up a couple of years ago with an independent auditor being established, as well as a civilian review panel with the independent auditor dealing with use of force and the civilian review panel dealing more with harassment and discrimination without the same powers that as the professional independent auditor had. Given your breadth of experience in law enforcement and national perspective, how would what would be your comments on establishing an independent auditor and the degree to which that is effective?
So thank you for that question. You know, each department is different, but as long as there is accountability and responsibility for those officers' consequences of their action. And so with that, certain situations do require independent audit so that there can be unbiased decision made that represents the law enforcement community as well as the citizens that they protect. So it depends on the situation. It depends on the department, but I think at given times, independent audit is necessary.
Thank you.
Thank you. Next is Delegate Sullivan.
Thank you, Madam Chair. Thank you, Ms. Williams, for your presentation. I want to ask you briefly about no-knock warrants. The Breonna Taylor incident focused the nation on this issue. Do you have any statistics, I guess they'd be national statistics, on how often no-knock warrants, I'll just say, go bad, either with a violent result or entering the wrong home? How prevalent an issue is the no-knock? How many problems come nationally from no-knock warrants?
Thank you for that. I don't have those statistics readable. Of course, if one goes bad, that's one too many. It's kind of like asking the questions, how many safe flights successfully take off and land? We only know those that crashed or didn't have a happy landing. And so even still with just the knowledge of those that have gone wrong, those are where we put our focus, because again, one life is one life too many. But I'm sure that we can get those statistics, but there has to be better training. We have to look at the circumstances. And again, that's why we question that necessary versus reasonable standard.
Thank you.
Yeah. And I'm just checking. I think that I have no more questions for you. Thank you so much, Ms. Williams. Appreciate you being here. All right. We're going to now move into our invited speakers. I first have Captain David Wells of the Fluvanna County Sheriff's Office.
Madam Clerk, this is Madam Chair, this is Committee Clerk Kathy Ho. We are moving Captain Wells into the room.
All right, thank you.
Unmute your microphone, Mr. Wells.
Madam Chair, it's 5 minutes.
5 minutes.
I apologize. I'm not a Zoom specialist. Can y'all hear me okay?
Yes, I can. Thank you for being with us. You have the floor.
All right. Thank you very much. Good morning. And thank y'all for allowing me to speak this morning. I only have a few minutes for my comments, so I'll get right to it. My name is David Wells. I have served in law enforcement for over 25 years throughout this great Commonwealth. I currently serve with the Fluvanna County Sheriff's Office as a captain responsible for field operations. I am also a DCJS certified general and defensive tactics instructor. In 2015, I was fortunate enough to graduate from the FBI's National Academy. The use of force on our citizens by law enforcement is a very complex issue which should not be painted with an overly broad brush. Each encounter is different and needs to be looked at based on its specific merits. There are volumes of well-established case law that exist related to law enforcement use of force, excessive force, and qualified immunity. Qualified immunity was recognized by the courts to shield all government actors, not just law enforcement, from civil liability when acting in good faith within specific established standards as they were known at the time. Qualified immunity does not apply to criminal cases or gross and wanton misconduct. It exists as all government actors are human, and courts realize that good faith mistakes, sadly, can happen. If qualified immunity is ended, keeping good officers will become very, very difficult. They simply might not be able to afford the financial risk of getting sued every time they do their jobs. Let me discuss what I think we can do better. One key way is through better training. Current DCJS standards on the use of force are abysmal. There is no requirement to practice or retrain on hands-on tactics once you complete the basic academy. For me, that was over 20 years ago. The only use of force related training mandate is for annual firearms training. If all you train on is your firearm, what do you think your brain is going to default to in the heat of conflict? During conflict, the body produces adrenaline and the mind produces emotions. Those are physiological and psychological responses. Without proper, well-rounded training, these responses can take over. When they do, control, mental focus can evaporate, and horrific behavior can result. Control and mental focus is gained through constant and habitual training. If you only train with your firearm, you will revert to your firearm. You have to be trained on hands-on use of force as much as you train on your firearm. We have to update our standards for training and our practices. However, this requires time, money, and staffing to train the way we should be training. Chokeholds are another topic that frequently get mentioned. In 15 years as a defensive tactics instructor, I have never taught or promoted the use of a chokehold. They are dangerous if used incorrectly. However, if lethal force is justified, if there's no other option, it may be the only way to save the life of an officer or a victim. There has to be room to use chokeholds as a last-ditch option to save the life of a victim. Another item to discuss is no-knock search warrants. In my 25 years of service, I've probably been involved in 3 no-knock search warrants. There is a time and place for well-planned no-knock entry. The examples that come to mind would be a hostage rescue or an armed subject call. Due to the complex and changing dynamics of evolving incidents, you should not limit times and the means of execution of lawfully issued search warrants. Often, an early morning, well-planned search warrant execution can actually reduce conflict and reduce the chance of injury because the target is asleep or otherwise not active in the home. Civilian review boards are another matter. I worked for an elected sheriff for the past 14 years. He remains responsive and directly accountable to the citizens of Fluvanna County. I serve at his pleasure. More importantly, just like all the members of this committee, we are accountable to our citizens every 4 years. If they do not approve or agree with our performance, they hold the power to vote to install a new person to lead and to set new policies. I see no need for separate review boards for sheriffs. Let the people speak on election day. There are ways, however, we can improve accountability. One key way to help accountability and hiring practices is through legislation mandating background checks and the sharing of employment records of law enforcement officers with other law enforcement agencies. I've conducted pre-employment background investigations for many, many years. And there have been time and time again when I hit a wall when I do a background investigation, all I get are dates of employment, and that is all, no further information. I've also had past employees who show up at other law enforcement agencies and no one ever called this agency to do a background check on them. That should not happen. I ask that you give us the tools and the training to do our jobs. Law enforcement is dynamic and absolutes can be difficult at best. We really do want to do better. We want there to be 0 calls that end in unnecessary tragedy. However, the judicious and prudent use of force is sometimes needed to stop a threat, to save a life, or to make a lawful arrest. I just ask that you do not rush to pass legislation when there has been time to explore all the options and consider all the outcomes. Rush decisions can often have unintended consequences that can hurt the very people you are trying to help. We are all in this together as Virginians, and I thank you for your time, and let me know if I can be of service.
Thank you so much, Captain Wells. I do have a question from Delegate Mike Mullen for you.
Yes, ma'am.
Hello, Captain Wells. Thank you so very much for being able to take the time to talk with us today. I had a couple of questions for you about your statements about qualified immunity.
Yes, sir.
Is it your assertion today that individual officers would be the payer in situations where an officer was to be sued? Or is it more likely that that would be the insurance carrier for the locality to whom that officer was working at the time?
Again, I'm no legal expert, but my understanding would be, depending on the nature of the suit, the individual officer could be on the hook for paying for the defense cost. And we're a small rural agency and we're not particularly well paid. And I have a lot of young people who have just started families and they're worried that if qualified immunity is ended, that'll open up floodgates and there will be a lot of lawsuits that'll come out, whether justified or not in the end, but those initial legal costs they have to pay up front could actually devastate them and ruin their households.
Well, Madam Chair, follow up?
Yes, Delegate Mullen.
As an attorney, I can tell you that just simply wouldn't be the case. No one would sue someone who is otherwise judgment-proof. There's no financial incentive to do that. The other thing that you mentioned about qualified immunity was that you said it would be a disincentive for good officers to be able to enter into law enforcement. There are many jurisdictions throughout the United States that do not have such rigid qualified immunity laws. Is your proposition that those places don't have enough law enforcement?
Again, sir, I can't speak for what I do not know from other states. I know in Virginia, there's currently a fairly large crisis, and I believe it's a national crisis, trying to recruit and retain good quality officers, the type of individuals we need to do this job, who are in it for the right reasons because they actually want to serve their community. Perhaps it's a misunderstanding on our end about the qualified immunity, but I know my officers, and I've heard it echoed throughout the Commonwealth, other officers are worried that they could be subject to a lot of frivolous lawsuits.
And I certainly understand that concern, but it's my observation. Oh, I'm sorry.
Question?
No further questions, Madam Chair.
All right, thank you. Thank you. Delegate Wright? Delegate Wright, did you have a question? Your hand is up. Yeah, you're on mute.
Yes, thank you. Yes,
Sure.
Being on the Public Safety Committee for years, I appreciate the responsibility that we have for providing law and order and public safety for our citizens throughout in the rural areas where a lot of people live. The Sheriff's Department and the local police are really first on the line, on the front lines to provide us this protection, of course, along with the state police. I've heard a lot of calls, had a lot of calls recently from sheriffs and chiefs of police concerning some of the legislation that's being considered this year, including defelonizing the assault on a police officer, immunity, and the civilian review boards, and they're very concerned about it. The problem they're having now is recruiting enough officers to fill the positions, and the training that's currently required is very expensive. I guess my question mainly for you, Captain, is what effect do you think that the legislation that's been considered is going to have on the retention and the recruitment and the morale of our local law enforcement that I think is doing an outstanding job and that needs our support? I just want to know what you think the effects will be on the hiring and retention.
That honestly all depends on the General Assembly and, what restrictions get placed on us. Like I said, I've worked most of my career in a rural environment, so I cannot speak to what occurs in large urban jurisdictions. Out here, we have a very good relationship with our community. Over the past 2 months, I probably gained 5 pounds because people have been bringing us cookies and dropping off pizzas and sending us thank you notes just to show their support for us. So here in smaller rural counties, we work well with our people. That being said, our pay is also on the lower end of the spectrum generally, and people that want to come work out here can be very difficult to get the qualified people we need as it is currently. And if my deputies feel and prospective deputies feel that there's going to be more restrictions and more liability, and it's going to be harder and harder for them to do, what our jobs in. And if our jobs aren't clear, they're not going to go. When I first started law enforcement, for one opening, you'd have 500 people applying. If I can get 5 or 6 applications that I even want to interview right now for one position, it's amazing. And it scares me that the candidate pool is shrinking because people don't want to do this job anymore. And we really need good people with the right mentality and the right attitudes to do this job. We don't want to end up with badge heavy people that should not be doing this job. So it's going to be a difficult challenge.
Thank you so much, Captain Wells.
I appreciate those remarks,
Yes.
Captain Wells. And I just want you to know that's the same type of feedback I've been getting from our department in this area. We're having a terrible time recruiting and retaining officers as it is now. And they have a tremendous job. They go out there every day not knowing whether they're coming back home or not to their families. So we also in our area.
Delegate, right? I'm sorry.
Thank you, Madam Chair. I've been trying to speak for several meetings now, and I appreciate this opportunity.
Oh, sure. No, absolutely. Thank you. And thank you, Captain Wells. We're going to next move on to Chief Wright from the Chesapeake Police Department.
Madam Chair, we are connecting Chief Wright to the meeting. And Chief Wright, unmute your microphone and turn your camera on, please.
Good morning. Can you hear me? Good morning. Can you hear me?
Oops. Yes, I can, Chief.
Very good. Good morning. Thank you, Madam Chair, Mr. Chair. I am Kelvin Wright, Chief of Police for the City of Chesapeake and a former president of Virginia Associations of Chiefs of Police. As a police chief, discipline is one of my more important responsibilities. Discipline for violations of department policy may range from counseling to dismissal, depending upon the degree of the matter and the frequency of violations. I think it's important to mention that we, that is my department, we have about 150 policies. And within these policies contain the methods, practices, and philosophy for how we deliver law enforcement services to our community. Furthermore, it is my responsibility to ensure that if police personnel, be they civilian or sworn, engage in criminal activity, that they are also dealt with properly and swiftly by utilizing the criminal justice system. I am aware of citizen review boards, and the first question I have is, what is or are the intended purposes of such an entity? Other questions I have include, but are not limited to, are they constituted to review my actions? Is it in place of the chief of police, or are they above it or alongside of it? Isn't discipline the sole responsibility of the police chief? These are the ones that immediately come to mind, but let's look at the data that we have thus far with regard to citizen review boards. One thing that research has found is that citizen panels often aren't as strict as police chiefs when it comes to finding fault and administering discipline. For example, law enforcement takes lying very seriously. It is almost always grounds for termination. Citizen review panels may think that this is harsh, but under Brady v. Maryland decision, lying disqualifies an officer from testifying in court. So if an officer's value in court is lost and there is documented evidence of lying, we have grounds for dismissal. Not reinstatement, not reassignment, but dismissal. Let me provide two more examples for you to ponder as you make this decision. In my city, if someone
just message her, we don't know which one. We message her and tell her to get rid of one of them.
Yeah. Someone else is talking. Okay.
Can I remind people to mute their microphones, please? Thank you. Continue. Chief, you have the floor again.
I reclaim my time. In my city, if someone is given time off without pay or terminated, it is first reviewed by a human resources director, a city attorney, and a city manager if that person grieves the employment action. If the employee grieves that time off or dismissal, they are afforded a grievance hearing. That hearing panel consists of 3 civilian employees of the city. They have no law enforcement experience nor training. The city puts on their case and the grievant puts on their case and a decision is made. For the record, I have terminated people who should not be in law enforcement and a citizen grievance panel has reinstated them. The matters for which these people were terminated were very serious, including theft, lying, assault, excessive use of force, and incompetence. So think about that for a moment. A civilian review panel's decision to put someone back to work who should not be in law enforcement. I would not hire someone with such a record, nor would I tolerate the continued employment with my agency. Yet, if you have a citizen review board, this is likely to occur. I urge all of you to consider the consequences very carefully before you do what will be difficult to undo. I suspect the last thing this legislative body wants to do is make things worse. For my agency, we have a rather in-depth and comprehensive use of force policy. For my agency, a use of force report is required for any use of force beyond mere restraint. All uses of force are received or reviewed by multiple levels of supervision, including the sergeant the officer works for, their lieutenant, the captain. Additionally, the lieutenant of ethics and conduct reviews them, 3 police majors, a deputy chief, and finally me. At all levels of review, all of the people whom I have identified are required to scrutinize the reports, videos, and any other evidence to make certain the use of force was proper within policy and according to the law. If we identify policy violations, we correct them. If we identify training deficiencies, we correct them. Furthermore, on occasions, we even consult with subject matter experts to help us identify and determine if the use of force was proper, that our training regiments are indeed adequate, and that our policy is not just up to date, but that they reflect the prescribed actions to use force and that there are no ambiguities. Additionally, if we identify potential violations of the law, we consult with our Commonwealth's attorney to determine if criminal charges are appropriate. For my department and those that are similarly situated, I submit to you that we do not take the use of force lightly. We go above and beyond to make sure that we're doing things right. If a citizen review board is mandated to review use of force, I ask, what level of training will the civilians receive? Will they receive at least the level of training a police officer receives? Will they be required to receive use of force training annually like my officers do? Is their decision binding? What if the decision is clearly wrong? Is there an appeals process? And will it apply to all agencies that provide law enforcement services, including sheriffs, campus police, private agencies, and special conservators of the peace, which are all certified by DCJS? Furthermore, are your actions addressing an identified problem that exists here in the Commonwealth of Virginia? I submit to you to have a civilian review use of force without knowledge, experience, and proper training is akin to a layperson telling a doctor how to administer medical procedures. This can be a slippery slope, which we should not step onto at all. Significant problems will be far-reaching, and consequences will emerge, perhaps further undermining confidence in law enforcement and in government. I further submit to you that we should proceed with caution and deliberation to ensure that the remedy does not cause any harm. Nevertheless, there are many civilian advisory committees, as opposed to citizen review boards, across the state that meet and confer with the chief to discuss community issues and to discuss needed change in their departments. However, we only have a few and citizen review boards.
The chief, if you could wrap up.
Thank you, ma'am. I'm close. I'm almost there.
Okay.
1 minute. If it desires to have more information about citizen complaints or even internal complaints, and how the chief dispenses discipline and disposes of these matters, I think this should be an area of focus and improve transparency. Most people whom I have spoken to are pleased with the lengths that we go to provide police services, and that we have thorough and rigorous processes in place to protect citizens from those who do not serve the public nor law enforcement's interests. As I conclude my comments, let me state clearly, I do not support the use of unions nor citizen review boards when it comes to matters that fall under the responsibility and purview of a police chief. If the chief is not doing his job, then perhaps you need another chief. We need only look at recent events that has taken place in other cities and see how unions have all but taken discipline out of the hands of the chief. Unions that are empowered to involved in disciplinary process can ruin the authority of the chief and continue the presence of bad actors. I don't think that is what we want here in the Commonwealth of Virginia. If the goal is to have greater citizen involvement and input and transparency, I recommend citizen advisory committees, and I also recommend the General Assembly draft laws which require us to gather and publish certain data points, much like they did last session for the collection of traffic stop data. I also urge this body to adopt the proposals submitted by Virginia Association of Chiefs of Police by amending Virginia Code Sections 15.2-1705, 1707, and 1708. Finally, let's not administer medicine to the healthy, rather help them to be better stewards of the public trust. And thank you for your time, and I stand by for any questions.
Thank you so much, Chief. We're going to start with delegates we haven't heard from. Delegate Lindsay, you have a question?
Thank you, Madam Chairman. Yeah, am I live on the mic?
Just yes, you're on. If I can ask delegates just one question, so people have an opportunity. Go ahead.
Yeah. And Chief, I'm quite familiar with you. You know, we know each other personally. I'm familiar with your reputation in your city. But you know, I asked, how do you match your comments with the recommendations from Noble as it relates to some of the very same subject matters that you're touching upon today, and especially in light of the fact that you know, that the community is crying for an opportunity to look behind the curtain and be certain that there's transparency, because that, in the judgment of many, gains public trust.
Thank you, Mr. Lindsay. I'm a member of NOBLE, and I think that their recommendations are indeed in alignment with my comments. I have had the opportunity to speak with a great number of groups and people, and when I tell them of the processes that we have, I think they seem to be very receptive of the processes that we have. And when I provide to them the data with regard to use of force, they are absolutely amazed at the number, how small the number is for use of force here in Chesapeake.
Hey.
Our challenge is being able to provide that information with a little bit more detail in a different arena so that that data is readily available at the hands of people rather than them having to call the office of the chief of police or the council members to get this data.
Delegate Scott.
Good morning. Thank you, Chief, for your comments. The first thing that I'm hearing, I just want to kind of get some things straight. From my understanding, the police academy that new law enforcement officers are certified through, I want to say they're 30 weeks and maybe some OJT, something like that. I think somebody doesn't have me on, is not on mute, so I'm getting some feedback. If you could appear on mute. And so I'm tired of the analogy that I've heard about 4 times this morning about police officers being doctors. Doctors go to school for 4 years undergrad, 4 years of med school, and then probably 2 or 3 years in residency and more. So it's no comparison to looking over a doctor's shoulder to looking over a law enforcement's shoulder and being able to see clear misconduct. And so I think we need to take a look at that. I think some of the comments that you make, and I know you and I know your reputation, I know what you're doing, some of the things that we want to change, they won't impact you as much, but they will impact some of the other bad actors that are not taking the disciplinary actions that need to be taken. Because what I'm hearing every time from almost all law enforcement across the board, and we're not, I know I'm not anti-law enforcement and anti-police. I think we need the police, but we need the police to be good, and we need them to be guardians of our community and not be as though I think and not seen as folks that we should be afraid of. So my question to you is, how do we make sure that we get some improvements beyond what we're doing right now if we don't do anything other than to take away some of the ability of the unions and some police officers to get some protections beyond the chief, because it's obvious that chiefs are not firing people in immediate discipline action. Otherwise, we wouldn't be in this position. So I'll wait your comments. You may be an exception.
Thank you, Mr. Scott. First and foremost, I think that what really needs to happen is that there needs to be more ways to decertify bad actors. Currently, there's only 3 things that you can do to be decertified in the Commonwealth of Virginia. And that is 1, just fail to maintain your certification. 2, not take a required drug screen. And 3, being convicted of a criminal act. Now, notice earlier I talked about someone lying. I can tell you I have terminated a significant number of people for lying, and only to find out that these people end up in law enforcement somewhere else, maybe in the Commonwealth of Virginia, maybe in an adjoining state. And these people come to or at least call our agency to find out what was the reason for the person's termination, but yet they hire them anyway. I submit to you, someone who cannot be trusted, who lies to us, should not be in law enforcement. So therefore, we need better tools to be able to decertify someone and keep them from have gun will travel. There should be penalties for hiring someone who has demonstrated that they shouldn't be in law enforcement. The other thing that I'd like to say about helping us is, we are very limited as to what kind of information we can share with regard to personnel actions. So what I suggest is that we be able to at least publish information about a complaint. You don't have to mention the officer's name. You can mention the basic, what the complaint was, our findings, because a lot of times we receive complaints that are not substantiated. In fact, I think that my department, we receive about 36 complaints about police services annually. So that's 3 a month, and only about a third to about 40% of those are substantiated. And use of force complaints are even smaller than that. But I think there's a better way to communicate and be transparent with citizens so that they have this data that is right there at their fingertips. And I'm sensitive to your comments about, yes, doctors go to school a lot, a long term to become a doctor. But I submit to you that the level of training that we provide our people with regard to use of force and the scrutiny that it receives on my agency, from my agency, I think that you would be hard pressed to find any fault with us saying that we do not do things properly with regard to make sure that the use of force is not something that is used haphazardly, and unequally applied.
Can I just, Madam?
One question.
The issue, and I understand what Chief Wright is saying, but I guess I just want to 1 second.
Yeah.
I'm leave it.
Delegate Scott.
Problem is not with cultures like Chief Wright. It's about us trying to respond to all of these other cultures, Chief Wright, that are not like yours.
All right. We're going to move on to Delegate Davis. The last question, Chief, from Delegate Davis.
Thank you, Madam Chairwoman. Chief, I appreciate your comments. I just wanted to get clarification on one thing. You had talked about the unions preventing accountability. And so I wanted to get your thoughts just to make sure I understood, because there's a number of articles out there, even on CNN, where it talks about police unions and collective bargaining, which was just passed in Virginia, protecting and shielding officers from accountability and stopping chiefs like yourself from doing what you believe is right for the community you serve. Would that be accurate? And to that extent, would you do you believe that there should not be that collective bargaining, but rather have that power rest with the chief, like you were discussing?
I think that if people want to have unions and they want to discuss wages and salaries and working conditions, that's fine. But those things that fall directly under the police chief's purview, which is discipline and hiring and firing people, I think that those should remain the chief's exclusive roles and responsibilities, that the union should not have the ability to influence the outcome of discipline.
Thank you.
All right. Thank you so much, Chief. Appreciate you being here.
Thank you.
All right. Next, we have Dennis Parker from the Caliber Association of Private and Mental Health Providers.
Madam Chair, we're bringing Mr. Parker into the meeting. Mr. Parker, I'll ask you to unmute your microphone and turn your camera on. Thank you.
Good morning. Can you hear me?
Yes, I can, Mr. Parker. Thank you so much for being here. You have the floor. 5 minutes.
Yes, ma'am. Yes, ma'am. Thank you, Delegate Herring and members of the committee. To do justice, we want to just to give you a little bit about Caliber. We're a mental health provider organization. And many of the things that we're going to speak to today, we're going to go through very briefly regarding no-knock warrants, because we agree with Dr. Ray and Dr. Williams as it relates to the banning of them. We also agree with regards to Civilian Review Board needing to have a little bit more influence and authority, and agree with Chief Wright specifically as it relates to having more transparency and accountability. And in that regard, we would hope that there would be some type of public database that we could have where officers have been formally found to have misconduct that would be public and people would know and would be transparent with regards to holding them accountable and being able to deal with the have gun will travel phenomenon that we find ourselves in. But we want to spend most of our time this morning with you guys, if we will, in the area of use of force, and specifically because we spent a lot of time, I think it was Delegate Price that raised the issue regarding people that have intellectual disabilities. But we want to talk about the people that we serve that have mental health issues. And increasingly, the U.S. criminal justice system has become the first responders for individuals with mental illness and substance abuse use disorders. More than ever, our jails and prisons are expected to provide appropriate services and treatment to this growing population they serve. Many times, we as communities are sending police officers in to respond to situations that require their support along with properly trained mental health professionals. In a mental health crisis, people are more likely to encounter police than medical help. As a result, 2 million people with serious mental illness are booked in jails. Nearly 15% of men and 30% of women are booked into jails and have serious mental health conditions. In 2012, jails and prisons housed 10 times as many people with serious mental health illness as state hospitals. Or, as Sheriff Leonard of Chesterfield County has stated, his jail has become the new central state. He's not properly equipped, as he states, to deal with the issues that the people in the community have regarding mental illness, but he's forced to. 45% of jails and 53% of prisoners have substance abuse use. The vast majority of these individuals are nonviolent criminals. Most people in jails have yet to go to trial, so they're not yet convicted, but they're arresting there with short-term sentences for minor crimes. How do we get here? The reasons are simple and tragic. We arrest people with mental illness more often than those without these conditions, typically for nonviolent crimes or lower level offenses. They stay in jail longer, where they decompensate, and then they get into a system. How do we break it? First and foremost, with specific emphasis with that population, we must prevent people with mental illness and substance abuse disorders from encountering the criminal justice system in the first place. That demands a robust crisis care continuum that includes crisis teams, short-term crisis stabilization, peer services, and the like. A comprehensive continuum that requires collaboration and coordination between mental health providers and first responders, including local law enforcement. Police officers are not always equipped, as we've heard from Captain Wells with regards to specific training. He said as if he's trained on guns more than he's trained on anything else, he's going to default to that. And it makes sense to me. I spent 20 years in mental health, and that's why, and I learn something new every day with regards to the application of training. But we should not be stepping down some of our crisis services, as it appears we're doing right now with some of the attempts in the Department of Medical Assistance. We need to be stepping those up. Specifically, we need to create urgent walk-in clinics with private providers and community services, booking, screening, and assessment teams, and diversion of treatment programs. And this doesn't even begin to talk about the cultural dissonance that exists within the members of the African-American community as it relates to police officers. I can tell you as a 50-year-old man that has never been arrested or engaged with the criminal justice system outside of anything positive, I still avoid police officers when I see them. And at a meeting with one of the county executives at Chesterfield, she was saying that she taught her children that police officers are a safe place. I've never told my children that. Unfortunately, I've had to tell my children, whatever he says or she says, you do respectfully. I don't care if he curses you out. The most important thing for you to do is to get home, and then we'll deal with it. That is not a conversation that I should have to have, but it is one that I have instead. Ultimately, going forward, we must support a well-funded, comprehensive system of care for communities of everyone at risk of having mental illness or substance abuse use disorders to reduce the use of force. I'll be quiet now, and if anybody has any questions, again, I want to thank everyone for allowing me to talk, and if you have any questions, I'll be happy to ask.
Thank you so much, Mr. Parker. Delegate Price has a question.
Yes, thank you. I guess my question is some other comments, and I just want to be very clear. The legislation that we've been working on was for mental health crises, substance use disorders, and developmental disabilities. So I just brought up one in the other question, but I appreciate your testimony. Another suggestion that I heard last night from the community was that training for the nuances of these three categories should not be just the first responders, but through the entire justice system in order for there to be real justice. And so for public defenders and prosecutors, judges, but throughout the whole system, would you support that? And do you have any input or feedback on that suggestion?
Yes, ma'am, Delegate Price. Thank you for asking me that question. I would support that, but I would take it a step further. I think I would agree again with Chief Wright with regards to the area of expertise he has. I'm not a police officer, nor do I play one on TV, even though I did sleep at a Holiday Inn last night. I am a mental health person, and I have been in that field for 20 years. And so that, I think, is a specific trait and professional characteristic that I think needs to be involved and engaged into that system. I think it's separate from police officers. I think they need to be a part of the team. I don't think a police officer can be properly trained in a crash course on how to deal with mental illness and that light. I think that, and it doesn't require, and I want to be clear about this, it doesn't require that every mental health professional be a licensed therapist. I think that there are levels of it that we can have towards engagement in that regard. Hopefully I answered your question.
Great. I believe that's it for the questions. Thank you so much, Mr. Parker.
Thank you, ma'am.
Right. And for our committee members, we're going to pause just for 1 second. There's a technical issue before we continue on with our last invited guest, and then we'll get into the public comment. you so much, Madam Clerk. I will let everyone know that our invited speaker guest, Lindsay Lawson Battaglia from Racial Justice Alexandria, is not with us right now. So we will move into the public comment, public testimony section now. I'm asking the speakers limit their comments to 3 minutes. To be fair and respectful to everyone, we will be using a timer. And so when I ask that you suspend, if you could just start wrapping up your comments, I would be appreciated. To members of the public offering testimony today, again, please keep your microphone muted until I call on you to speak. Please identify yourself, whether you represent a particular group, and please speak again no more for 3 minutes. I don't anticipate this to be an issue. Failure to adhere to any of these guidelines will result in you being excused from the meeting. For members of the committee, I ask that you use your raise your hand feature so I can recognize you to speak. We are good on time still, but these are individuals from the public, so I ask you to use your discretion. And so we will start with our first public speaker. I have Jen Carter from the Humanization Project.
Yeah. Madam Chair, we are moving Ms. Carter into the meeting.
All right,
just a moment. Ms. Carter, please unmute your microphone and turn your camera on. Thank you.
Yes. Can you all hear me?
Yes. Welcome.
Thank you. First, I want to thank you, Leader Herring and Chairman Hope, for allowing me to speak today. I want to speak to two things. First, briefly to the need of oversight for DOC, and second, more thoroughly to the expansion of earned sentence credits for all people behind bars. My name is Jen Carter, and I'm the co-founder of the Humanization Project. We work to humanize people behind bars in the eyes of the general public with the hope of driving criminal justice reform. Through our work, we are in touch with people behind bars on a daily basis. During COVID, we have borne witness to some truly appalling things, like people being saran wrapped into barred cells, being denied drinkable water in 90-degree heat with no showers for over a week during a time when we are all supposed to be sanitizing, and that's just one example. As I believe we are all seeing the need for oversight of policing right now, please also create some oversight for DOC. Their well-intended public policy and what is actually occurring at different facilities across the state do not line up, and there needs to be some recourse for that. Regarding earned sentence credit expansion, this special session was called specifically to address two things: the budget and criminal justice reform. This bill may be one of the only bills that addresses both very strongly. But right now, I want to specifically speak to an issue that I know will come up as you consider this bill, and that is the idea of parsing out people with specific crimes to not be able to benefit. I want to be clear, doing that is pandering to fear-mongering and worst-case scenarios and is completely contrary to evidence and best practices. First, initial crime does not dictate future crimes. In fact, sex crimes and murder and manslaughter have the lowest recidivism rates. Second, what counts as violent under Virginia law is not as cut and dry as that sounds. If you sell enough drugs, that's a violent crime. If you got a ride from a friend you didn't know well and they stopped and robbed someone, you also get charged with a violent crime. So we need to think about what we are parsing out here. Here's a hint. It gets back to systemic racism. Leaving out violent crimes will only further perpetuate the racism inherent in this system. In addition, prisons don't reduce violence, they actually produce it, both in the populations contained within them and their communities that they were forced to leave. What does actually reduce crime and violence is creating better citizens, and that is done best through giving real incentives to be better, and the Earned Sentence Credit Bill does just that. Those real incentives will also create safer conditions within our prisons, not only for people behind bars, but also for the officers who put their lives on the line every day to work there. Eliminating certain populations will actually make our prisons even less safe because those not benefiting will be able to prey on those who want to maintain their earning levels. Think for yourself about the purpose of prison. Is it just to punish, or is it to actually create better citizens and increase public safety for all of Virginia's citizens? In conclusion, if you're trying to safely make space in our prisons for social distancing during COVID, here's your answer. If you're trying to begin to right the wrongs of racial inequity inherent in our system, here's your answer. If you're trying to help with budget for staffing in the prison system, as well as programs and potentially providing money for education, healthcare, and much more, here's your answer. If you're trying to truly make Virginia a safer place for us all, here's your answer. Please pass the earned sentence credit expansion bill for all people behind bars during this special session. If anyone would like more info or would like to speak to me about this bill or any other issues, I'm always happy to connect. Thank you again, Leader Herring and Chairman Hope and all the members of the committee.
Thank you so much. Thank you so much for being here and joining us.
Thank you.
Next, I have Jen Carter from the Humanization Project.
That was me.
Hi, Jen, I'm sorry. Dominique Martin. I apologize. Dominique Martin from New Virginia Majority.
Madam Chair, we're moving Dominique Martin into the meeting. Dominique, when you join the meeting, please unmute your microphone and turn your camera on.
Good afternoon. Can everyone hear me?
Yes, we can hear you. Go ahead.
All right. Good afternoon, Chairwoman Herring, Chairman Hope, and members of the Joint Committee. My name is Dominique Martin, and I'm a Policy Research Analyst at New Virginia Majority. This special session, the General Assembly has an opportunity to address longstanding issues in policing. Similar to the efforts to reform our criminal justice system, substantive, procedural, and structural changes to policing and public safety are needed to move Virginia closer to a just society. The circumstances under which law enforcement are allowed to use force against citizens must change, and the ways in which we hold our law enforcement officers accountable in such instances must also change. Today, I will be citing a 2020 report by the University of Chicago's International Human Rights Clinic, which found that American police use of force standards fail to live up to international human rights standards. Regarding the use of force, Virginia must adopt the best practices use of force standards at a statewide level. According to the University of Chicago's report, the best standards include a use of force policy that generally establishes the magnitude and nature of the threat that must exist and the level of certainty police officers must have to justify the use of that force. Some policy suggestions in the report call for a gradual escalation of the use of force. Some list a series of measures an officer must or should take before resorting to such force. Also, to incentivize intervention from fellow officers when they witness misconduct, a duty to intervene policy with protections for the intervening officer should also be enacted. The report goes on to say that a policy must prescribe what happens after force has been used, who must be notified, and how an investigation unfolds from there on. These findings bring me to civilian oversight. We have entrusted our law enforcement officers with the authority to use force, including lethal force, to perform their duties and maintain public safety. However, this authority must be subject to proper scrutiny as an effective check on law enforcement. Independent civilian review boards with the authority to pursue investigations, subpoena witnesses, and participate in disciplinary decisions are essential transparency and accountability tools that should be enacted. The country lacks a comprehensive, standardized, and effective legal framework that places specific conditions on the use of force and establishes mechanisms of accountability. This presents challenges in police accountability, police uniformity, and information transparency. Virginia's General Assembly has the power to enact a statewide use of force and accountability framework for the state and local police departments. Use of force and accountability policies can assist the appropriate state agency, police departments, and local authorities with data collection techniques that are crucial to determining the outcomes and ethics of policing strategies and tracks progress towards policing goals set both statewide and at the local level. In closing, impacted communities have been bringing awareness to issues regarding policing practices, procedures, and accountability long before the events of recent months and even recent years. Police reform that centers racial equity and the human rights of people of color and the working class have been delayed long enough. I thank this committee for taking up these issues during this special session, and I hope that this session will result in meaningful policy change for our communities. Thank you very much.
Madam Chair, unmute your microphone, please.
Next, I have Phil Hernandez from the Commonwealth Institute.
We are bringing Phil Hernandez into the meeting. Please unmute your microphone and turn your camera on. Thank you.
Good afternoon, and thank you, Madam Chair and members of the committee. Thank you for the opportunity to testify today. My name is Phil Hernandez. I am the Senior Policy Fellow and Counsel at the Commonwealth Institute for Fiscal Analysis. I'd like to focus my time on the issue of criminal justice debt. Across the country, the criminal justice system has really come to rely on court-imposed fines and fees, even for the most minor offenses, giving rise to a form of cash register justice that places the most severe financial burdens on those who can least afford it. And I'm sure many of you will likely recall the issue of fines and fees receiving national attention after the shooting of Michael Brown in Ferguson, Missouri in 2014. And those events prompted a US DOJ investigation of the local police department there, which found an over-reliance on fines and fees disproportionately at the expense of Black residents in the city, which, as the DOJ explained, fundamentally compromised the role of the courts. Now, the question that many have been grappling with since Ferguson is how unique is Ferguson? Is it being replicated in other parts of the country? Recent research suggests, unfortunately, that Ferguson is not unique. And based on new TCI analysis where I work, Virginia has a problem as well. So here's the main point I want to convey. In Virginia, fines and fees are assessed at higher rates in the courts that serve areas with the most Black residents or residents who live in poverty. And just to put some more detail on that, in fiscal year 2019, across all court areas, $82 was the average amount of fines and fees assessed on a per capita basis. But that number jumped to $147 in the courts serving localities with the highest share of Black residents. Now, the arrival of COVID-19 and the economic turmoil that it has caused has only underscored the need for reform in this area. And so in this special session, the most important first step that the General Assembly can take is to put in place a statewide moratorium on fines and fees. The Virginia Supreme Court had previously had a moratorium in place, not expired at the end of July. It needs to be reinstated in no small part because in this economy, no family should have to choose between paying court debt and putting food on the table. So I thank you for the time to testify. Look forward to working with you in the special session. And TCI will be releasing analysis this week with some more details on what I've talked about today. Thank you.
Thank you so much, Mr. Hernandez. Next is Sean Perryman.
We are bringing Sean Perryman into the meeting. Mr. Perryman, turn on your camera and unmute your microphone, please.
Okay.
Go ahead.
Good afternoon, Madam Chair and members of the committee. Thank you for allowing me to testify today. My name is Sean Perryman. I'm the president of the Fairfax County NAACP, but I have the great privilege this afternoon of speaking on behalf of not only Fairfax County, but the Loudoun, Arlington, and Prince William County NAACP in a consolidated testimony. The NAACP, along with many other groups, advocates for smarter, results-based criminal justice policies to keep our communities safe, as well as end racial disparities at all levels of the system. We are unfortunately living through unprecedented times, dealing with two dual pandemics, one of public health and one of racism. The racial inequities in policing and criminal justice have long been recognized, but meaningfully addressing that root issue of racism has yet to be seen. As Virginia reckons with this issue, it is imperative that during this special session, we recognize the state-sanctioned violence against people of color and pass policies directly designed to right this historic wrong. In addressing these issues of the pandemic and these dual pandemics, our collective NAACP chapters demand specific policy change for addressing racial inequities in policing and in criminal justice, as well as increasing COVID-19 protections intended to help safeguard marginalized communities. I'll start with an issue that we have talked about several times, removing SROs from schools. Virginia schools are among the worst offenders, shunting disobedient or non-compliant kids to law enforcement at nearly 3 times the national rate. Right now, many localities, including Fairfax County, continues their MOU with SROs, even though we're going to a virtual environment this fall. So essentially, we have police officers being paid to protect empty schools. One of the other issues that I'll only touch on briefly is demilitarizing the police. In this time of cutting budgets, it seems unwise that we would continue to have military-grade weapons given to police departments. Earlier today, you've heard a lot about ending qualified immunity. It's shocking to me to hear some law enforcement officials speak out against that. Without qualified immunity, you essentially have no jury that can, or judge that can have any sort of accountability for police officers. They also spoke out in some cases against civilian review panels. So in that case, you'd have no one who's really able to have any sort of oversight over police. If they do care about having bad apples on the force, as they say, then we need to have some sort of accountability. As a professional myself, an attorney, if someone were to sue me for malpractice or sue a doctor for malpractice, we wouldn't expect them to be experts in the field. We would expect them to be able to judge complete malpractice in their profession, which I think the public is able to do. The other issues that I wanted to bring up besides civilian review panel is to have subpoena power for those civilian review panels. We have one in Fairfax County, and they are only able to briefly review what the police do and either rubber stamp it. They cannot make recommendations. They cannot subpoena evidence, and this hampers their ability to be effective. I would also talk about cash bail reform. This is one of the issues that all the NAACP chapters are aligned on. On any given night, Virginia jails hold over 28,000 people. Pre-trial justice is a racial justice issue. And even though Black Virginians make up about 20% of our state population, they comprise 43% of our jail population. During a time of the pandemic, no one needs to be in jail simply because they are impoverished. We need to make sure that we are not sentencing people to death just because they cannot afford bail.
Mr. Perriman, if you could wrap it up. Sorry.
I will.
You can wrap it up.
Yeah, no problem. Legalizing cannabis is also one of the many issues that we wanted to bring forward. And I thank you for your time. I think all of these issues deserve your attention and will lead to a safer Commonwealth. Thank you.
Thank you so much for being with us and for your comments. Next is Marjorie Singer.
We are bringing Marjorie Singer into the room. Marjorie, unmute your microphone, please. Okay.
Yes.
Go ahead, Ms. Singer.
Okay. Thank you so much for the opportunity to present this information. Chairs Herring and Hope and members of the two committees. My name is Marjorie Singer. I'm the Legislative Vice President of the Virginia chapter of NOW, which is the National Organization for Women. We have members throughout the Commonwealth, and we advocate on behalf of women and girls. I want to talk today about the school to prison pipeline, and specifically the abuse to prison pipeline as it affects girls and young women, particularly girls and young women of color. Can you hear me?
Yes.
2008 U.S. Department of Justice study showed that the increased arrest and incarceration of girls over the past 20 years has not been the result of increased criminal activity or violence. Instead, more girls are being arrested and incarcerated because of the aggressive enforcement of non-serious
Madam Chair, I can't hear her.
Right. Are you on mute?
I think she muted herself.
Oh. I think we lost her.
I'm here. I don't know how to unmute.
Oh, there you are. Okay. Please continue. You got about a minute, 50 seconds.
Okay, excuse me. The National YWCA reports that girls and women of color experience criminalization and racial profiling by law enforcement in ways that are overlooked by the current policy narrative. A major report in 2015 by Georgetown University and others stated quickly that sexual abuse is one of the primary predictors of girls' entry into the juvenile justice system. In short, the data suggests we need a comprehensive legal approach to decriminalizing behaviors in schools that will dismantle the school to prison pipeline and the abuse to prison pipeline as it applies to girls and young women, particularly those of color. Thank you for the opportunity to bring up these points.
Okay. Thank you so much. Supervisor Bodie is not here, so I'm going to move to the next one. It's Valerie Slater.
We are bringing Valerie Slater into the meeting. Valerie Slater, please unmute your microphone and turn on your camera. Thank you.
Good morning, Chairs Herring and Hope and other committee members. Thank you for the opportunity to give testimony this morning. My name again is Valerie Slater, and I'm the Executive Director of Rise for Youth. And I'm speaking as a community advocate, a community leader, and a mother not just to my own Black children, but to the many Black, Brown, LGBTQ, differently abled, and other marginalized children that I stand and fight alongside for justice and equity in schools. This morning, I'm here to ask your support to ensure that the issue of removing SROs from school is a part of the work covered in special session, and that we enact legislation that creates the path for each school division in Virginia to receive the funds necessary to fully fund schools with all of the needed support staff and end the reliance on police departments for supporting children in public schools. The school divisions in Virginia must employ staff who are well equipped to work alongside students in need of therapeutic interventions, guidance, vocational training, mentorship, and yes, even discipline. The removal of police and increasing support staff within Virginia schools will allow for a paradigm shift in the way we address the educational and support needs of our youth in public schools. This paradigm shift is monumentally important because we know that there is a difference in school divisions across the Commonwealth based on the communities our young people live in. Too many of our young people live in communities facing economic, recreational, and even employment opportunity deprivation. And we know that the communities facing these devastating challenges are overwhelmingly Black, Brown, and other ethnic populations. You see, these communities, they've created cultures that seek to obtain what every Virginian should have access to. Only they have devised alternative means. But these environments are producing toxic stress in our children. And young people are coming to school every day in fight or flight mode. These young ones have very little to no access to proper support. But instead, their behaviors are criminalized rather than recognized as cries for help. To help you put this in perspective, consider that Black youth ages 15 to 17 make up 21% of Virginia's population, but there are 57% of students suspended, 49% of students referred to the justice system from school, 42% of youth referred to court services units, and 68% of youth incarcerated in Virginia's juvenile justice and juvenile prisons. These numbers are even higher when you overlay the statistics of differently abled and LGBTQ youth. These stark and troubling statistics tell a devastating story that in Virginia, we are significantly more committed to harshly punishing Black youth than we are to providing educational opportunities for them. This must change. And the first step towards making these paradigm shifts is moving away from school policing and into school funding for every support our children need to realize their own American dreams. We must stop missing opportunities to identify when students are exhibiting symptoms of trauma versus unacceptable behavior. And we must employ ways to support and correct youth in both of those instances that do not lead to school pushout, arrests, or incarceration. Virginia educators, administrators, and school support staff must become gatekeepers of success rather than gatekeepers to the school to prison pipeline for children in every zip code and community. We must invest in support staff in schools that are professionally trained in conflict resolution, and not police officers. We must ensure support staff can relate to and are reflective of the young people and communities they serve by way of credible messengers. Now is the time to dissolve Virginia School Division's reliance on police departments for school support. These partnerships have proven to only enhance the likelihood that Black, brown, and differently abled youth become entangled in Virginia's juvenile justice system. I ask you to please ensure removing SROs from school is an issue addressed during special session and with a focus on redirecting funding used to pay police officers and other resources that they be directed to increase funding for support staff in Virginia schools with a targeted focus on schools serving communities suffering the greatest deprivations. Ensuring this issue is addressed meaningfully during special session with a path to elimination will demonstrate to the youth, the families, and the educators in Virginia public schools how much you, their elected officials, truly care about them through investing in their success. The future of our next generation depends on the investments that we are willing to make now. Thank you for your time and your consideration.
Thank you so much, Ms. Slater. I appreciate it. Next is Stephanie Rizzi. I apologize if I'm mispronouncing your name.
We are bringing Stephanie into the meeting.
Thank
Stephanie,
you.
please turn your camera on and unmute your microphone. Stephanie, please unmute your microphone. Unmute your microphone, please, Stephanie.
Sorry, thank you.
Hi.
Hello. Good afternoon, chairs, Herring, Hope, and members of the two committees. Thank you for your time today. I am Stephanie Rizzi, a member of the Richmond Transparency and Accountability Project. We strive to build safer, healthier communities by organizing for a more transparent, accountable, and fair police department, which makes space for the needs and concerns of the most vulnerable of city residents. Our TAP has been advocating for community oversight of the police for almost 4 years. And almost 2 years of that work was devoted to gaining access to the Richmond Police Department's data on policing in our city. At the same time, our PD was denying racial disparities in policing in our city. It was simultaneously denying access to records regarding the racial demographics of traffic stops, pedestrian stops, and arrests that would substantiate the experiences of our citizens. Over that 2-year period, we submitted several Freedom of Information Act requests, which were denied. Some of our FOIA requests were unanswered. The city even requested that we pay almost $5,000 for access to data that would tell our community how they were being policed. Ultimately, we did gain access to this data, but it should not take 2 years of work to have this information made publicly available. Specific to civilian oversight, these bodies cannot effectively perform their duties if they don't have access to police records and data. That also means having access to the most up-to-date data in order to understand trends in crime and policing, rather than having to take on a multi-year fight to obtain these records. Putting the power to subpoena police records into the hands of these oversight bodies would greatly enhance their ability to perform their duties. More broadly, greater transparency and FOIA requests across the board would put more power in the hands of the people by giving them access to data long denied to our communities. Furthermore, these investigations should be open to the public. If civilian oversight bodies are to shine a light into the darkness of policing, then their records must also be subject to FOIA requests. Beyond the ability to subpoena records, civilian review boards must and should be granted investigative authority, including the power to subpoena officers and witnesses. This is not a power currently granted to local oversight bodies under state law. These bodies cannot effectively perform their duties without these powers. A civilian review board can't properly investigate complaints or claims of excessive use of force if the officer involved has no obligation to appear before that body. We are working across the state to develop solutions to our local policing issues, but we need you to give us the tools to do that job well. We need state law that allows meaningful civilian oversight, including both CRB subpoena power and more transparent FOIA laws that increase accessibility to data. Thank you so much for your time.
Thank you so much. Appreciate it. Next is Adrian Fikes.
Madam Chair, it seems that Adrian Fikes has left the meeting. Would you like us to move on to the next speaker?
Yes. Let's move on to Carla Turman.
We will bring Carla Turman into the meeting. Carla Turman is joining the meeting. Carla, please unmute your microphone and turn on your camera. Thank you.
Hello. Madam Chair Herring, Chair Hope, and the committee members. Thank you for allowing me to speak to the Joint Committee this afternoon. My name is Carla Turman. My dad, with County Deputy Clifford Dicker, who was killed in the line of duty on December 6, 1994. His murderer was Christopher Sean Wheeler, who was 15 years old and had been in and out of juvenile detention for most of his life. That morning, when Dad went to pick him up on another juvenile petition, Wheeler confessed that Dad allowed him to change out of his hunting clothes, but instead he retrieved his .22 caliber hunting rifle and shot my dad. Then he used Dad's own service weapon to fire a fatal shot into his head. Wheeler was found guilty of murdering Dad and sentenced to 43 years in prison. As the murder happened just 26 days before Virginia's no parole law went into effect, my family knew that he would be eligible for parole at some point. We didn't realize that it would come just short of 7 years into his 43-year sentence. To date, he has been eligible for parole 12 times, most recently just last month, and we are still waiting on that decision. When denying parole in the past, the Virginia Parole Board has cited his history of violence and their opinion that he is a risk to the community. When someone is denied parole because the parole board considers them to be a risk to the community, I don't feel that they should be considered for parole the very next year. Each time that Wheeler has a parole hearing, my family relives that terrible day in 1994. It is like constantly knocking off a scab, causing the wound to bleed all over again. In 1994, my family was handed a life sentence. We were given a life without our husband, our dad, our granddad, and our great-granddad. We will never get parole from our life sentence. His murderer should not get parole either and should have to serve every second of his 43-year sentence. My family is not the only one affected by parole eligibility of offenders. There are many victims that are submitted to this torture of fighting to keep their offender in prison. Whether it is annually or not, every parole hearing rips that scab right off of a healing wound. The specific focus of today's meeting may not be parole laws. However, I feel it necessary to ask that Virginia's no parole law not be abolished. Please do not consider only the offender in any decision regarding parole or no parole laws. I ask that you consider the victims as well, for there are many of us. Thank you for your time and for your consideration.
Thank you so much for being with us.
Thank you.
Thank you. I will tell the members that we do now have Lindsay Lawson Batalia back, and I apologize if I'm mispronouncing your name. She will have 5 minutes. She was an invited guest.
Madam Chair, we are bringing Lindsay Lawson Battaglia into the meeting. Lindsay, please turn your camera on and unmute your microphone. Thank you. We can see you.
Okay, great. Good morning. Thank you. My name is Lindsay Lawson Battaglia. And if you'll give me 1 minute to sort of get my screen up here. I am here on behalf of Racial Justice Alexandria, and we're a group of organizations and individuals here in the city who are hoping to implement the platforms of the movement for Black Lives here in the city and also in Virginia. The movement for Black Lives obviously grew out of Black Lives Matter, and they created a policy platform with designed to that was created by Black voices and informed by Black experience. the thing that they're demanding is that an end to the war on Black people. And so what that really means is reducing incarceration, over-policing, and investing in communities in ways that make them safer and more productive. My background is as a criminal defense attorney. I practiced for about 10 years, mostly in Fairfax County. I also spent my most recent job was as a drug policy reform manager, and that was in Washington, D.C. So my area of expertise really has to do with criminal justice reform. So there are a few things that I would like to address. I'm going to talk about something that I haven't heard other people talk about before, because it's a little unusual, and it has to do with mandatory minimums that maybe aren't mandatory minimums. And what I mean by that is charges that involve sentencing of a term of years. So for example, when you look at possession with intent to distribute a Schedule 1 or 2 drugs, the sentencing range for that offense is 5 to 40 years. If I plead my client, or if my client has a bench trial, the judge can begin sentencing at 5 years. The judge can suspend a portion of that 5 years, though. And in fact, the Virginia sentencing guidelines midpoint for that type of offense is actually 12 months for somebody who has a very limited prior record or no prior record at all. If, though, I opt to have a jury trial with my client, the jury has to begin sentencing at 5 years, and they can't suspend a portion of that time. So although the jury sentence is technically recommended to the judge, judges don't tend to interfere with jury sentences. So effectively, that means it really disincentivizes clients' abilities to have a jury trial on offenses like that. So there are a lot throughout the Virginia Criminal Code. So what I would ask the committee to consider doing is amend the sentencing ranges so that everything begins with 0 days in jail, all the way up to what your kind of ceiling is for that event. The other thing that I wanted to address was the legalization of marijuana. So all the research shows that Black people and white people sell and use marijuana at the same rates, and yet Black people are still arrested and charged at about 4 times the rate that white people are. So I know we've just decriminalized marijuana, and that's certainly a step in the right direction, but that is unlikely to change the disparities, the racial disparities that exist when we're talking about a civil fine, and you still have the other attendant disadvantages that come with having contact with police. So if you have a drug-related offense, you can have trouble getting housing, and that's a big problem for people here in the city of Alexandria, which sort of leads me to my final point, and that has to do with community policing. So community policing sounds really benign. It sounds like it's simply the police who making an effort to have a better relationship in the communities within which they work. But what I can tell you is that I live in a predominantly white community. In my community, there is no community policing that's involved. The police are only in my community if we summon them. And that's really what people in these over-policed communities are asking is not to have better relationships, as much to have fewer relationships with the police. So I would just ask the committee to be mindful when you're discussing community policing, that really essentially means over-policing communities of color. So thank you very much for taking the time to listen to me. I appreciate, and thanks for the work that you're doing.
Thank you so much for being with us. All right. That is it for our witnesses today. And I just want to take this opportunity to thank members of both committees for your participation and your questions. And as we head into special session and the next General Assembly session, I think that we have a lot of work ahead of us, but I appreciate you and certainly your suggestions about guests. So with that, the committee will rise. Thank you so much. We're adjourned.